Good afternoon, everybody, and welcome to yet another podcast on business networking on QE Talks. Our guest today is Advocate Madhuri Gaikwad. Madhuri Gaikwad is graduated from Pune University and has received a law degree from JC College, which is part of the University of Mumbai, the year 1997. She has been practicing for more than 26 years in civil disputes where she has dealt matters related to property, housing societies, banks, mergers and acquisition, execution, and practice also in cooperative court, DRT, charity commission, city civil, and high court. She has also been empaneled on Union of India and real estate companies, corporates, and banks. With this, now she is exclusively dealing with estate planning that contains drafting of wills and codices, trust deeds, succession matters, uh, which is testamentary matters in High Court, real estate, corporate, and currently is actively spreading awareness on will through her lecture. Today, she is going to talk about a very important and sensitive topic with us, which is succession planning, something which a lot of us don't pay much attention to. And that is one of the main reasons why I have invited uh, Madhuri to come onto the show. She's a good friend. I'm sure she'll spare a little time from her very, very busy schedule to tell us about this very important aspect of business and also our personal lives, which we rarely pay attention to beyond a certain point. We think it's only for the old people very often. But today we're going to talk about why it is important for all age groups. So welcome to Business Networking Podcast, Madhuri Gaikwad.
Thank you. Thank you, Vipul.
So Madhuri, let's dive straight into the topic of succession planning.
Yes.
So if you can tell us what is succession planning and why should someone do succession planning?
Well, Vipul, instead of going into the legal jargons, I would like to explain in very easy by giving a live examples why it would be necessary by telling you the situations, giving you the situations where it is utmost important. See,
Sure.
suppose if a person is retired and he want that his wife should get all the properties. She
Right.
should enjoy after him, but he is also having a kids. By just making a nomination, do you think that it will go successfully to his wife alone? No, it's not like that. It will be distributed between his children and his wife. So his wish of his wife getting everything after him does not survive. Then second situation might be there are special child or special children are there, mentally retarded, blind, or something like that. So if succession planning is not done properly, when they are alive, everything is fine. What after them? So they have to make the provision or do the planning in such a way so that child survives after them also for how many years. There are various ways which I will explain you later on how it can be done. Then third situation, suppose a person dies at young age. He is having wife, old parents. So what? If his wife gets married, where his parents will go if he has not done his succession planning? So these are the situations, just giving an example ki how why succession planning is so important. These are the
Well,
only few situations. There are worse situations also. I have seen mentally retarded children. They
correct.
are not suffering only, and children who are deaf, dumb, blind, and also suffering with some other disease. So succession planning might be these situations are there or not there. It is utmost important to see that after you, it is not after life, I would say, in your lifetime also. So if it is done properly, you also enjoy that property.
Correct. So what are the various steps that an individual must undertake if he or she wants to get into succession, proper succession planning, and what are the some of the few things that one needs to keep in mind?
Yeah. See, they can either make a will, will, wherein they can write down who will get what and how it should be done. Second important thing is that they can have form trust, private trust in their lifetime itself, and they can put the property in the trust and the beneficiaries who will be the beneficiary. But the only disadvantage in this is that person cannot sell the property then if once it is put in the trust. Second thing is, if he doesn't want to do it in his lifetime, then second thing is that in the will he can annex that trust format. This way I want the trust to be. He can direct the executors or trustees to whom he has assigned the work of fulfilling his wish after him. So the trust will be formed after him, and who will be the beneficiary? So that cannot be sold, but the benefits can be enjoyed by the beneficiaries. These are the two ways.
Okay. So basically, there are two options, at least to individuals,
Yes.
which is one is making a will and bequeathing it to whoever they want to give it to, or form a trust which will then operate independently after the person is involved.
In
That be the right
people, there are other things also like power of attorney, but power of attorney only sustains only till the person is alive, not after him. So these are the 2-3 things if we keep this in mind. And fourth, another thing is that in company law there is an exception. If mutual funds or shares are there, if the person is nominated to whom he wants to get the benefit, so after him it is automatically transferred in his name. There is this is an exception actually for nomination.
So nomination in the case of let's say purchase of shares or mutual funds, the nominee is actually the person who benefits out of that after the person is no more. But that's not true for any other.
No.
Okay. So the ideal situation would be that whoever somebody wants to make sure that they get their property, and if they want the same person to also receive, the shares and then they should take appropriate action. Would that be right? Okay. So in this case, I have a question because this would obviously mean that a lot of people make their will at a very early age. As life progresses, they may want to change some of the things in the will. For example, when they made the will, maybe they had no children, but as years progress, there are one or two children that come into the picture. Then they want to make sure that the children also get part of the property, or they may not have been married when the will was made. They make the will that they get married, or something like that. So, can a person change their will, and how often can somebody change their will?
See, there are actually 2 ways. One is make a new will.
Right.
Or second thing is that they can add a codicil. In simple language, I can say like a supplementary we have for exams.
Right.
Like a supplementary to the will, that is codicil. You can make first codicil, second codicil, third codicil, fourth codicil. But remember that if the will is registered, then the codicil also has to be registered. If first will is registered, if you are cancelling that will and making second will, then that second will also needs to be registered. That's the main and important issue. Otherwise, it doesn't have any existence also. If it is not registered, then it's okay. The second will or execute codicil also need not be registered.
So whatever process gets followed for the first will, that has to be followed for the subsequent wills, so that that document becomes valid. Otherwise, the original document which was registered is considered valid.
Absolutely.
At what stage does somebody make a in your experience, and as per you're the expert. So how often, what do you think a will should be made, and typically at what age will actually be? And that will explain the current gap that is there. If there is.
Okay, there is no age actually. After the person becomes the major,
Okay.
he should draft a will. Whether he have any property, he doesn't have. But in will, always I suggest to have a residuary clause. Residuary clause is that clause wherein one person who is executing the will or writing a will mentions about the properties, might be movable or immovable, which he acquires in the future or he might get in the future. He explains about that, whom it should be given. So it's not always that he must possess some property or this or that, but it can be future property. See, the COVID has taught us very great lesson actually. So many people have now due to the lifestyle also, people are dying at young age. So we must take the lesson and do early as possible. And the will should be prepared in such a way so it helps in future also. So always one should take the legal help to draft the will, because there are certain things which person has in his mind but he doesn't know how to do it, and if it is done randomly, then it does not sustain in the court of law. So that precaution one should take.
Okay. Sure. So, there's a question which is related to this, which has been asked by Sakshi Shetty on the group. So, I'll ask you that question. So, Sakshi Shetty asks, how can a small business or family-owned business approach succession planning? I think she wants to understand it versus, let's say, a large corporate. How can they approach it?
See, the business might be small or big or whatever. In your personal will, you can mention it. That is the one part. But definitely, every business. See, recently we have so much of big war in big corporates about the succession. I would not prefer to take anybody's name over here. But big corporates, like giant corporates, they have their succession in place. Who will be the next? What if chairman or whoever is holding the position, though board of director have that authority, but the person who has given birth to that company or nurtured that company to such a high level, he will definitely see who has to be the next person who will succeed him to take that company ahead. So succession planning has to be in place. Who will be the next? Who will be handling that? Or who will be taking over? Because company is anyway not anybody's property if it is not private limited. But still, there has to be succession in company also. It has to be in place. That would be my response to your
So,
question.
in this case, typically, yeah, sure. So, one is aspect of internal succession planning, which company does. Let's say a company decides that in case there's any reason to change the uh, owner or the ownerism, or that's the internal part of the company. Saying that it, this one takes over and so on. Other is the legal aspect of what. So, which are the laws that exist, which govern this whole aspect of this whole succession planning in India? I mean,
See,
there are laws which govern.
company laws works actually. So one has to act accordingly.
Okay. So, how does it intertwine with, let's say, personal law? Personal laws is about a personal property. So, let's say a business owner has a certain uh, shareholding in a property, and that's their asset. Means that wealth that is going to be out of that business is their personal asset. So, how does that reconcile with succession planning in
He can always mention in his personal will that I am holding such and such shares of such and such companies. It is definitely he is owning that. Though company is owner, but that shares are held by him. So he has got every right to bequeath that. See, recently I have filed, one of the private limited company has been appointed as an executor. So they have filed the petition on behalf of the deceased. So company being a separate legal entity, it has their own rights. and the individual have their own rights.
Okay. So that can be then made sure that those are all in line.
Yes, yes.
So when you actually prepare a person, will you see this thing? I mean, do you look at their whole shareholding pattern and so on? If, let's say the person whom you are making a will for, let's say is the director of one of the private limited companies with the shareholding. So do you actually even consider those things when you're preparing?
Yes, definitely. And I ask my clients to be very specific. So those who are benefiting out of it, they should not be confused, or that undue advantage should not be taken off his property.
So I'm sure over the years, I mean, you've been in this profession now for almost 25, 26 years.
Yes.
So I'm sure you've had some very, very complicated cases coming to you, uh, especially in business families. It happens. Shareholding, very often, some of the ownership just because of a verbal undertaking between two family elders and so on. So how does, I mean, can you tell us a few interesting or complicated cases that you handle? Of course, you don't need to take names, but if you can tell us how it got resolved or how it got entangled. Because our people who are watching this podcast must understand the importance of it because all kinds of alliances are formed without maybe looking at a lot of the paperwork. There's not much clarity in terms of who owns what, who gets what in the case of the death of, somebody. So, in that element, so can you just walk us through a couple of very interesting cases? Because then we'll get a good sense of what happened afterwards.
Definitely, Vipul. I have several cases, but I would like to cite few uh, with example. Recently, I have done got one letters of administration. Letters of administration where the actually executor was not appointed. That's why it was letter of administration with copy of will. Otherwise, if executor would have been there, it would have been probate. In that, the lady who is herself gynecologist had four daughters. Her husband expired earlier. So one of the daughter, she is special, is mentally retarded, mentally challenged woman, I would say, because she is above 60.
Oh,
And she was owning one row house with her daughter, and other two daughters are residing abroad. They are gynac. Another daughter who is residing here, she is also gynac, to whom she has bequeathed. But this was a conditional will that you will take care of this sister of yours. So I am bequeathing my share to you. But here, in while applying for the court for getting the probate or letters of administration, consent of all legal heirs are required. Here, other two sisters gave consent, but this mentally challenged, she cannot give, na? Because she doesn't understand anything. So, we have in India got a provision to appoint a guardian for that. So, I have to get her sister to whom it was bequeathed as a guardian. She is also senior citizen. So, I got her appointed herself as a guardian. Then she consented and then she got that. So, this is the one case. In another case, means I will not refer the name. Witnesses were not alive. The witnesses who witnessed the will, witnessed the signature just, not the contents of the will. They were not alive, both of them. Two witnesses are required. So what to do? So what solution we got? And there is also a provision, not a solution. Ki the person other than the witnesses who has seen signing, that person can give affidavit, or we can prove the signature by just having a report of that signatures which he might have done in other documents and on the will. These are the way I have handled one of them. What I did, the servant was there at that time. He was there in their house for 40 years. He said that I have seen, so he signed. Then third one was that one lady was refused by all the doors were closed on her. We cannot do probate for this or letter of administration for this because she was not having the original will. it was lost or somewhere something, but she was having just a Xerox copy. So she said ki nobody no, they are saying ki it cannot be. I said it's okay, we can. Fortunately for her, no, that will was registered. So I asked her to get certified copy of that, true copy of that, and on that basis I have filed that probate. So it is not impossible. See, people are not aware. For Kachi, witnesses are not required. So when witnesses are required, when oral will can be done, people are not aware.
So when does normally, I mean, so if you can elaborate and tell us when does, a witness come into the question? So that will just help to understand.
See, witnesses are mandatory for the will. For will,
that is while
witnesses
this
are mandatory.
will is being signed, but at the time that the probate is happening, at
No,
that
we
point,
have to file witness affidavit. He has witness. His signature is the crucial thing.
Correct.
If there are disputes also, it can happen only and only on signature, nothing else. Only on signatures. See, the soldiers who are fighting on the border, at
right,
the war front, if they are making oral will at that time or writing on the piece of paper, there is no witness required. The person to whom he has told orally that this is my will, and if he dies over there, he can go and tell that this was the wish of that person and it has to be fulfilled. But if he comes back from the war front, then it doesn't survive. He has to write down the will. Two witnesses are required. So two witnesses are mandatory.
and do those two witnesses have to be there when the will is getting probated?
Yes.
Or they have to be.
They have to be. If they die, they cannot help now.
No, that I know. But I'm saying
Sometimes what happens, people, witnesses at that time who were signed as a witness, they are not ready to come in the court and to give witness or evidence he has signed before us.
oh,
So we have to find several ways. We have to send warrant and this and that. At that time you agreed by. Now you come forward and tell the court whether it was done under pressure. You must have done on your own will. Na?
oh.
So these are the way. But witness is crucial.
Another question I had was regarding to nomination. There's a lot of misunderstanding, especially about membership of cooperative society and ownership of flat. So let's say the nomination given in the society is in the name of someone, and the will, or if there is no will, then the letter of administration which comes into the process may not be favorable to the nomination. How does that work? I mean, how does nomination come into the picture? If you can just throw a little light on this, because very often a lot of people misunderstand nomination as, especially in a cooperative housing society, to be the same as a will.
Definitely, it is very sensitive, crucial question which you have asked, and
Correct.
it's always misunderstood and misconceived actually. And unfortunately, professionals do misinterpretation of whatever it is, and they misguide the people actually. It's not like that. See, nominee is mere a trustee, and it is a very settled law. It is a settled law since 85, 83. In housing society. Exception is that what I said earlier is the company law. Otherwise, nominee is mere trustee till actual beneficiary or legal heirs come on the record. He is a caretaker in simple language.
Okay.
Doesn't have any right. So, there are judgment also. Two judgments basically are there. One of Bombay High Court. One earlier basic judgment is of 1983. And recent judgment is of Justice Oak, wherein in very detailed way about the nomination it has been elaborated. Supreme Court judgment, which was very much misinterpreted, it was actually for West Bengal Cooperative Housing Society, and ours is Maharashtra Cooperative Housing Society.
Correct.
So that judgment doesn't apply over here. That is meant for West Bengal. And about the succession, what happens? See, people who are working on the committee, they are actually doing honorary. They don't get any salary for doing all these things. So they don't want to be any dispute or anything between the family members.
Right.
So what basically they do, see if there is in few societies they act over smart. That's the other thing. But suppose see if single person is there legal heir and they are aware, if he is giving all the documents, society should transfer it in his name. Other thing what society do, they transfer it in the name of the nominee, but in bracket they write nominee.
Right.
On share certificate itself. So if the advocate is checking or the bank is checking the chain of documents, if it goes for loan or something else for sale,
Right.
then we come to know that this person is nominee. Who are the actual legal heirs? Nominee might be one of the actual legal heir, but it does not mean that he is the only legal heir or she is the only legal heir.
Right.
Basically, it is not a ownership. It's just
Right.
a caretaking. So when society sees that the dispute cannot be resolved or there is a dispute between the legal heirs or they are confused, they tell like, Baba, you go and take the succession. People actually know only about succession. They don't know about letter of administration.
So can you, of course, as a continuation of this, can you just tell us about succession and letter of administration? I'm sure it's a question in the minds of a lot of people. What happens in case the owner of the flat or the apartment passes away and there is no will? I'm sure there are a lot of my friends who are in committees of their cooperative societies. Or in decision making position when they very often are at the wit's end in terms of what to do. So just tell us a little bit. Of course, not detailed, because that will, I guess, require a lot
If
of
the person has left a will, then he has to apply for probate. If he is residing in the presidency town, one of the presidency town is Mumbai. Right now we are dealing of Mumbai, so Mumbai. So person has to apply for probate.
Okay.
If the person dies intestate, that is intestate means he has not left any will.
Right.
Then that person can apply for letters of administration.
Right.
For immovable property, for flat. If there are only movables, like sometimes company shares are there, pensions are there, or other movable properties are there, then person can go for succession certificate. If the will is there and no executor is being appointed, then person has to go for letters of administration with will annex. Here what court does, when all these petitions are being filed, after procedures are followed up, the court appoints administrator to administer the estate of the deceased, and his responsibility basically is to distribute it in the beneficiary, and he is accountable to the court. He has to file the report to the court within 6 months. So these things are necessary actually if the person has died tested or intestate.
It's a 6 month process.
Yes, 4 to 6 months.
4 to 6 months. And typically, what is the cost involved? I'm giving out the lawyer's fee, but you can tell us
For
the
court,
other.
I can tell you. See, lawyers' fees depend upon.
Will depend on the lawyer. Yeah.
See, maximum court fee for this letter of administration and all these things is 75,000. And 75,000 starts basically from 11 lakh 50,000 or something like that. So people have to pay 75,000 because no flat in Mumbai is less than crore. Market value is taken up. So it comes at the most 75,000.
And how does it work in the case of other things like fixed deposits and all that? How does that happen for nomination?
No.
The
See,
nominee
bank, what bank does, if it is below 5 lakhs now, they transfer it by taking consent of other legal heirs and all that. But if it is beyond 5 lakhs now, then they ask if our get succession. If nominee is not there. If few banks, means it depends on either on survivor. So they transfer it.
But the nominee is the beneficiary in this case.
Not actually, but with the consent of, see, if the amount is less, there is no point in having a dispute if all the legal heirs are consenting. Now, for 5 lakhs, they don't have to go to court.
Oh. Because for mutual funds and for shares, you have mentioned, right? The nominee automatically becomes the person who is. So I was still confused before.
Nowadays, it has become mandatory actually. If the demat account is there, they ask you, no, you have to do nomination, KYC is done and everything.
Correct.
So it doesn't.
So we'll come to the question, which is, the reason why we are doing this podcast is to, talk about the fact that networking is a very important aspect of any profession. And, all the guests who have appeared on this podcast are networkers. So you are also one. You've been a member of BNI in the past. You're again a member of. And so how does networking work with you?
See, I'm very passionate about this subject, will succession. And wherever I get an opportunity, I create the awareness. I go to old age homes. Then I try to create awareness in study circles of chartered accountants and company secretaries. So in this way, BNI is such a platform where I can contribute it in very big way at one time.
Right.
It is building relationship. I can convince them or I can tell them, please do this.
Right.
It is utmost important. See, I have spent 26 years in the court and I have seen several disputes happening over the properties. After the death of the person, without enjoying that property, that person has left to the next generation and they are fighting over it, not enjoying themselves, their next generation is enjoying. So if we are taking care of planning this succession planning at the right time, dispute will not arise, people. So that's why I find that networking this is very important.
It helps you in getting your message out. Okay, so there's a very interesting question from Vinita here. So the question is, what are some challenges that companies commonly face during successful process, and how can they overcome them? So if you can just elaborate on this, because I think a question mainly related to companies. I think companies have their own policies in what we do. But any common things that you think they should do, and how they can overcome some of the challenges that they.
Challenges, that is what I stated earlier also. Companies, they should put down in writing or they can have a board resolution passed. This will happen after this. This person is not there. This will happen. That only. See, this is specifically ruled by Companies Act.
Right.
So it should go accordingly. By making a statement, it should not be taken in another way. It will not be inappropriate to misguide actually. It will not be appropriate to misguide the people.
So, a lot of our people who join us on this community are young. They are very, very young people who are in the process of building their business, who are looking forward to a career. Succession or things like succession and will is not something that is even at the back of their mind. Okay, being top of mind. So, what would be your advice to such people? Because they're building wealth and they're creating some intellectual property, they're creating, some real property. A lot of people own, are beginning to own houses, they made investments in mutual funds. So, what would be your advice to young professionals, young entrepreneurs regarding succession planning? Because, as you rightly said, life is very uncertain, especially during COVID. Notice how things change very, very fast. So, in that kind of a situation, what would be your advice to young business?
Vipul, irony is that in India, though the person is of 70, 75 years of age, he does not want to make a will. Why? There is a misconception. I will say it is a blind faith, or what should I say? If you make a will, person will die. How the person is going to die by making a will? So it's not just COVID, but today's lifestyle also. See, we have seen the child from 5 years of age till 90 years of age. He has seen what COVID has done the havoc on each age group.
Correct.
Each age group. But today's lifestyle, it was of COVID. But today's lifestyle, if we see 30-year-old is getting stroke, 25 years old is getting heart attack and dying. So this is the lifestyle which we have adopted. So is there any certainty about it? कि मैं नहीं मरूंगा ही नहीं, अमृत पी के आए क्या हम लोग? नहीं ना.
But I think it's got something to do with the way a will, or it has been shown in Bollywood movies, where typically when a person is about to pass away, is when they say, why don't you call your lawyer and get a will done, as if it's to be done in the last. So I think Bollywood has got something to do with this mindset that you right.
It's not always like that if the person understands exactly, but one should take the advice of the professional also, the person who is expert. See, just now I recollected while speaking to you. Earlier it was how it was, father at certain age, after he reaches 60, 65, he used to tell his children, this has to be distributed in this way.
Right.
It was just oral directions given, and his wish was fulfilled. I have seen this in few families who come to me for advice.
Right.
And they also take care of their mother also.
Right.
So what should we say? ये संस्कार है या education है? The purpose is that, see, the parents have done a lot for the whole life of their. They should also not be left on the road. See, sometimes what happened, the new girl who is got married, and if her husband unfortunately dies, she is thrown out of our house. She should also not suffer. So justice has to be given to all. So this is the only way to give justice.
Yeah.
That is what I think. So there should not be any delay. Let you have any property or doesn't have any property. But always you can make the provision in the same will. Whatever I might get, it should be distributed in such a way.
Thank you.
It should be done very, very after giving a thought. It should be done. Nobody should be biased in doing that.
Thank you, Adv, because this is sound advice. I hope people listening to this live, or those who will listen to the recording, will take appropriate steps, because it's a very crucial aspect, and we've seen how a lot of the families suffer after the business person is no more, because there is no clarity on how to take things forward. Very often they don't even know that there is a will there. Registration of the will, letting family members know that there is a will. And of course, the will is subject to change, like Madhuri told me, something that you can change over a period of time if the situations have changed. But having it in place will help a lot the family members, because they will be able to plan their future better, especially in the absence of the person. So thank you. Very, very nice, very sound words of advice by you, Madhuri. So what I can suggest is, you can tell us your email ID, in case any of the people listening to this want to get in touch with you and seek your advice on their own succession planning. They will get in touch. So if you can just tell us your email.
I will share.
Are you putting it on the chat?
Yeah, I'm putting the chat.
Okay, so if you put it on the chat, then I'll put it on the community, so everybody will have it. So you can get in touch with Madhuri, and then in case you have any more questions. And
I'll
then
share.
So Adv Gaikwad MV@gmail.com. Adv Gaikwad MV@gmail.com. Is that right, Madhuri?
Yes.
Okay, so that's the email ID for Advocate Madhuri Gaikwad. In case any of you would like to write in and I have more questions, please feel free to send her an email. Uh, and I'm sure she'll be happy to help you because
Yes,
she's an
definitely.
evangelist for Will, and she will take the time to, I'm sure, go into greater detail to help each one out with their individual uh, requirements. So thank you very much for your time, Madhuri. And I wish you
Thank
all
you
the
very much.
best in
Thank
this
you
and
so much.
look forward to interacting with you again. Thank you.
Thank you.